Good morning. This meeting of the House Select Committee on Restoring Law and Order will commence. I'd like to take just a moment this morning to address something that happened yesterday. This committee has gone to great lengths to treat the weighty subject matter before us with the dignity and respect that it deserves. One would think that anyone in Philadelphia, especially any law enforcement officer, at a time when the city faces a record number of homicides, carjackings, and serious crime of all sorts, honestly, would recognize the gravity of the situation facing everyone in the city and give it due respect. Instead, yesterday, while a mother was describing the pain of searing loss after the murder of her son before this committee, at the same time, supporters of the status quo were literally holding a circus outside the building, chanting and jeering with stilt walkers and people parading dressed up like lions, elephants, and zebras. I said it yesterday, and I will say it again today. This committee will not be drawn into the gutter, filled with circus animals, when the matter at hand is of such importance. Those who trivialize or question the legitimacy of this committee and these hearings, and those who have shared their stories here before us, are free to do so. But it will not deter this committee from fulfilling its mission to the people of this city, the people of Pennsylvania, and to the General Assembly. With that, we will turn to our first testifier today. We are joined this morning by Greg Rowe, Executive Director of the Pennsylvania District Attorneys Association. Greg, good morning. Thank you for being here today. You can remain standing so I can swear you in. Would you please raise your right hand? Do you swear or affirm that the testimony you're about to give is true to the best of your knowledge, information, and belief? If so, please indicate by saying, I do. You may be seated.
Thanks.
Very good. Greg, thank you again for being here today. You are recognized for your opening testimony.
And good morning. My name is Greg Rowe, and I am the Executive Director of the Pennsylvania District Attorneys Association and the Director of the Pennsylvania District Attorneys Institute, which is our education and training arm. I've been in this position for approximately 2 years, beginning in January of 2021. Before that, I was the Director of Legislation and Policy for the District Attorneys Association for 2 years, from January of 2018 until January of 2021, when I became the Executive Director. Before that, I was the Chief of the Legislation and Policy Unit in the Philadelphia District Attorney's Office from 2010 until 2018. My primary responsibility there was to serve as a legislative liaison to the Pennsylvania District Attorneys Association. And before that, I worked for Governor Rendell for 6 years in his Office of Policy and Planning, and I was the Senior Policy Manager for Public Safety. And in the last year, I was also a Special Assistant for Public Safety, where I was the day-to-day contact with the criminal justice agencies within the executive branch. Our membership at PDAA consists of 66 of our 67 counties. The Philadelphia District Attorney's Office withdrew from the PDAA in November of 2018. The PDAA was formed in 1912 for the purpose of providing uniformity and efficiency in the discharge of duties and functions of Pennsylvania's district attorneys and their assistants. The association today continues to further its purpose through legislative and policy advocacy, communications and outreach, both among prosecutors and on behalf of prosecutors, certain training programs, and collaboration with colleagues, officials, and stakeholders. The PDAA continues to operate as a vehicle for the effective exchange of information among our approximately 1,000 members. The PDAI, again, which is our education and training arm, was founded in 1983, and it was founded for the purpose of developing and providing educational materials and training seminars for DAs. And the PDAI indeed provides numerous and diverse trainings for district attorneys, assistant district attorneys, and law enforcement. I've indicated in my testimony some of the topics that we cover, and this is just a small sliver of the areas that we cover, but they include, but are certainly not limited to, human trafficking, search and seizure law, victims' rights, implicit bias, community engagement, firearms prosecutions, restitution, ethics, and domestic violence. Again, these are a very small number of the topics we cover each year. By way of example, some of our trainings include a hands-on, dynamic, multi-day trial advocacy program, a multi-day basic prosecutor's course for new or newer assistant district attorneys. And for each of the past 2 years, we have offered a multi-day training on prosecuting homicides. And I'm pleased to tell you that beginning in next year, we're going to be offering a multi-day training on successfully achieving justice for domestic violence and sexual assault victims. During the pandemic, like many other organizations, we had to shift and really began to offer a robust virtual platform of trainings. And that included, among other things, a series of trainings on procedural justice. And we partnered with the Villanova School of Law on that endeavor. At all times, the PDAI strives to ensure that our trainings demonstrate the importance of and how to ensure the voices of victims are always heard. Our trainings are collaborative. While we utilize elected DAs, first assistants, their top trial deputies, we also bring in individuals from other groups and other entities. Representatives from the Attorney General's office participate in and sometimes lead portions of our trainings. We've partnered with Villanova Law School for our procedural justice training. And we've had representatives from, among others, the Sentencing Commission, PSP, the State Police, CHOP, and the University of Pennsylvania Law School present to our membership. The PDAA firmly believes that training and collaboration among law enforcement is a vital component in making our communities safer. With all that said, I will try to answer any questions you may have.
Thank you, Greg. I appreciate that. We're going to turn to Sarah Decker for questions. Ms. Decker, you're recognized.
Thank you, Mr. Chairman, and good morning, Mr. Rowe. Thank you for being here with us today. Thank you also for all that you do for the Pennsylvania District Attorneys Association and the Institute. I have a couple follow-up questions. I want to drill down on some of the things that you just discussed. The first being what you mentioned about membership. I think you said that there are 67 of 67 counties in Pennsylvania. 66 are members of the PDAA. And I think you mentioned that the Philadelphia District Attorney's Office withdrew in November of 2018. Is that right?
Yes.
How extraordinary is that you have one county that is not a member of the Pennsylvania District Attorneys Association?
It is unusual. To the best of my knowledge, a withdrawal of a county happened, again, to my knowledge, once before in the early to mid-2000s, Montour County. It was an issue, again, before my time, but it was an issue about an investigation that spanned different counties, and Montour eventually rejoined the association. So certainly unusual not to have a county within our association.
And I think you said that the association was formed in 1912. I wrote this down. You said it was for uniformity and efficiency in the discharge of duties and functions of DAs and assistants. Is that right?
Yes.
So it's been in existence for more than 110 years at this point. And this
Yes.
is only the second instance of someone withdrawing from the association.
That I'm aware of, yes.
Do you have an understanding as to why the Philadelphia District Attorney withdrew his membership?
At the time, the DA told the media that our policies that we support were too punitive and were too focused on incarceration. We would obviously disagree with that characterization. We do support laws that keep dangerous and violent offenders off of our streets and incarcerated. And at the same time, we support measures like the Clean Slate Initiative that help individuals with records get jobs. We support a bill that we hope gets to the governor's desk at the end of this month that would decriminalize the possession of fentanyl test strips. That's really good harm reduction.
And I know that in addition to advocating for policy, you mentioned a number of other benefits that are available to members of the association and people who receive trainings from the Institute. So as the executive director, do you see a benefit to remaining a member, even if perhaps you disagree with the policies of other district attorneys who are members or those for which the association is advocating?
Yes, I believe that the association and the Institute provides many, many, many great benefits to its members that span multiple areas, multiple issue areas, and our members just get a great value out of it. We obviously do a lot of legislative and policy advocacy, and we've really leaned in over the last several legislative sessions on legislation trying to help the most vulnerable victims, particularly victims of domestic violence and sexual assault, and the elderly and children. We tightened up the rape shield law. We helped domestic violence victims with an enactment of a strangulation law, as Representative Ecker certainly knows. We enacted with our friends at the Coalition Against Rape a law creating a crime of sexual extortion, one of the most hideous crimes that exists and is a crime that gets worse and worse. We were active supporters of Marcy's Law, which gives victims a remedy if their rights are violated. And at the same time, we've supported what I mentioned earlier, the Clean Slate Initiative and Justice Reinvestment, which appropriately reduce the size of the prison population in a safe manner. But we do more than that. We write amicus briefs to the Supreme Court. We provide case law alerts to our membership because our courts, our appellate courts, offer and give a lot of opinions, and they are typically effective immediately, and our assistants need to react, and at times adjust practices and procedures based on the decisions that come down. We collaborate with important entities, particularly state entities, that are entirely relevant in the world of criminal justice, like the Department of Corrections, the Parole Board, the Office of the Victim Advocate, and the Commission on Crime and Delinquency, which provides training and grants to many, many organizations. We answer legal questions. You can imagine the world of trying cases, both trial and pretrial and appellate. A lot of questions come up. The world of prosecution is not easy, and issues may come up. For example, there may be a question from a county about an expert that's involved in their case, and they want to know a little bit about it. So they'll ask, and we'll get the information out to see if perhaps somebody in another county has dealt with that expert before. Possibly finding a good jury instruction on a crime, particularly when there's a new crime. It takes a while for the jury instruction committee to come up with the jury instruction. But you need a jury instruction if you've charged somebody with that crime. So we can provide that as well. There may be a question about how to interpret a statute. So we can help or put people in different counties together to have that conversation. That's part of the collaboration that we foster. We have a best practices committee, and we have committees, a handful of committees based on subject matter, where ADAs who work in specific fields get together quarterly, either in person or virtually or now sort of a hybrid. We have a child abuse committee, we have a traffic safety committee, we have a juvenile justice committee. And in broad strokes, they get together quarterly and they discuss cases they're working on. They may seek advice on how to handle matters that have come up, questions or advice on trial techniques, best practices that have emerged in the area, worst practices that may have emerged in the area, and everything in between. The other thing it does, and it's really great to see this, I think in a post-pandemic world where it's, everything's hard. The world's hard, and being a prosecutor is hard. There's a lot of trauma that's involved. ADAs are underpaid. There are a lot of vacancies throughout the Commonwealth, throughout the nation, in prosecutors' offices, as well as in public defenders' offices. Being able to sit with your colleagues and just vent sometimes, or share stories, can go a long way in terms of, I think, addressing prosecutor wellness. And our committees do really allow for that, and that does occur. And it's very special to see that dynamic occur. Finally, I do want to mention we do have a new committee that's formed. We're actually going to be meeting next week for the first time on gun trafficking, illegal gun trafficking. So it will be assistant DAs, Attorney General's office, getting together and discussing what's going on, how to do investigations, how to prosecute cases, what trends are we seeing, because we're seeing gun trafficking throughout the Commonwealth. It's not just in large counties, it's not just in urban areas. I've said for years that crime knows no boundaries. I think we all know that, and gun trafficking certainly seeps into areas which before had not seen that. So the necessity for this committee is needed, and I'm looking forward to some robust discussions amongst our members on that committee.
Absolutely. Now, the Philadelphia District Attorney's Office isn't a member of the association, so will they be participating in that committee, to your knowledge?
No, the committees are available to our members only, so the answer to that is no.
Since the Philadelphia District Attorney's Office withdrew its membership, have any Philadelphia ADAs or the DA himself, to your knowledge, attended any of the trainings that are offered by the PDAA?
I'm not aware of any.
Or the PDAI?
Right, and for purpose of this, we can treat the acronyms interchangeably, but I'm not aware of any.
Okay. And I want to go back to something that you mentioned, and that was case law updates. I think you said that the Supreme Court, they can come out with new decisions every day. And can those decisions impact significantly, substantially, how an ADA needs to do their job, the law that they're enforcing, procedures that they need to follow?
Absolutely. Search and seizure. And remember, these cases apply throughout the Commonwealth. So if the Supreme Court or the Superior Court reaches a decision that says you can't do X, police officer, you can't conduct a search or a seizure unless X, Y, or Z has happened, that's a new rule of law, and that's going to apply everywhere. If there's a change in a time deadline to filing a petition, for example, that would apply universally throughout. So case law is universal. It applies throughout the Commonwealth in most instances. And yeah, as a result, the need to get that information out to our membership is really important.
Okay, and you say get it out to your membership. So am I right that those case law updates, they don't go to the Philadelphia District Attorney's Office anymore? Is that right?
Right, they go to our membership, which would not include the office, correct.
Okay. So I want to go back to trainings, because I hear that you're talking about all of these trainings that you offer, and I'd like to understand a little bit better what trainings are offered by the Institute, particularly focusing on new ADAs who may be straight out of law school, they're fresh in the courtroom for the first time, or people who've just never practiced in that area of law before. They're coming over from civil practice. So if you could talk about some of those fundamental training courses that the association offers, I think that would be helpful to the committee. Sure,
and we're extraordinarily proud of our trainings. We do a lot of them. Let me hit a few, and I'll try to be brief on them. It's hard to be brief talking about them because some of these are multi-day trainings. We do some shorter trainings, and I'll hit one or two of those, but our basic prosecutors course, for example, is a 3.5-day training. We typically offer it twice a year, and it is meant for new or newer ADAs. And there's a lot of information that they get. And just to run you through a few, there are presentations about understanding the crimes code, right? Crimes that are committed, crimes that you charge people with. There's a presentation from the Sentencing Commission, and you'll hear from Mr. Bergstrom next, on the sentencing guidelines, understanding and working through the sentencing guidelines. Sentencing guidelines can be complicated, and having an understanding there helps extraordinarily during plea negotiations and during sentencing. We have a restitution expert talk about what do prosecutors need to know about restitution. There's a presentation on understanding the rules of discovery, presentations on prosecuting domestic violence cases, and we've added presentations on prosecutorial ethics, gun cases, prosecuting gun cases, as well as juvenile justice and diversion. So there's more in those programs, but I think that's a good flavor that we cover in 3.5 days. Again, there's a lot of information, and I think for the ADAs, it's impossible to remember everything that you're told. I mean, that would be physiologically impossible. But it's a really good tool. It's a really good avenue to get information to them because they can rely on it. If they're back in the courtroom, back in their offices, they may remember, you know what, I heard something from the ADA from Chester County talk about domestic violence cases, and I'm going to look back through my materials. Maybe I'll shoot her an email. Or maybe I met somebody at the conference. Maybe I sat next to somebody, not from my county, and we've remained in touch, and I'll email that person and try to get a sense of what the answer is. Mm-hmm. Another training that we do, it's not for new DAs, but it's meant to help assistant DAs really get better and excel, is our trial advocacy program. And we just completed one this past week, actually. It's about a 2.5-day training. And it is what you think about when you think about trial advocacy. It is you getting your hands dirty, you get a scenario, you come up and you present, you're at a workshop, you hear from elected DAs, and again, the higher level experienced trial prosecutors talk about how to do opening statements, how to do a direct examination, how to do a cross, and how to do a closing. It sounds simple, but imagine doing that, being videotaped, and then having the elected DA of Montgomery County or Bucks County or whatever county look at your video with you and critique you. That's not easy, but that is a tremendous way to learn. There are trial advocacy courses in law school that are really helpful, and this is sort of modeled on, this is practical experience that's going to really challenge you. You're not going to sit and just take it in. You're going to sit, you're going to take it in, and then you're going to do, and then you're going to be told and work with somebody with a lot of experience on what you do great and where you can improve. And that's just a terrific way of helping you to advance in understanding what makes a really good trial prosecutor. We added a course last year on prosecuting homicide cases. The title of that says exactly what it is, right? There are so many different avenues within homicide cases, so we've had presentations on determining the causes of death in homicides by a first assistant and a former medical examiner. Video and cell phone evidence, a presentation from the Attorney General's office. There are so many cases now, and I think all of you know this, where you got to use information or video evidence, but information from a cell phone. You got to pull the information down. Not having that knowledge or not really becoming facile with how to do that or working with your law enforcement is a problem. So getting that information out there is really critical in these cases. And then one other, although there are a lot more, is an area that unfortunately we need more and more of, and that's presentations on domestic violence homicides. We see more of them. They are so, I know everyone would agree, they are so incredibly tragic. But those cases are sometimes different than a dispute over other issues. So that's our homicide case. We launched a series on procedural justice during the pandemic where we partnered with Villanova Law School. We had a national expert define and discuss the importance of procedural justice. A law professor from Villanova talked about policy issues that touch on issues related to procedural justice. And we had presentations from both DAs and first assistants and folks outside of the DA's association talk about community relations and trust building, identifying and trying to reduce implicit bias, diversion, reentry, how to form reentry coalitions in your county, and a presentation from Penn Law on understanding criminal justice data, both within your office and when you read articles, scholarly articles, or newspaper articles, or anything in between, which cite data, how to understand the differences between causation and correlation, for example, which is really important because there is thankfully, more and more data, but it's important to be able to know how to interpret it. Since then, we've had more trainings on that. We've had a training on conviction review. We have a training coming up in the end of October on LGBTQ victims, particularly in the area of domestic violence. So we do a lot there. And then the last one I'll mention is our Achieving Justice for Domestic Violence and Sexual Assault Victims. It's coming up next year. We're still in the planning process, but that's something we are focused on. Last thing, truly the last thing, is some of our trainings are shorter and are not necessarily multi-day. So there may be a case law update. We do lunch and learns, sometimes not for CLE credit, but we did one on the Post-Conviction Relief Act earlier last month. We did one a few weeks ago on the scintillating issue of federal habeas law, which certain people here will nod and say, yeah, that's not an area you normally get into, but if you have a case, you typically didn't study it in law school. If you don't really deal with it too much in a DA's office, but when it comes up, it's big, and you got to know the federal rules and how to deal with it. So we're able to fill in some of those gaps with trainings like that.
I mean, this just sounds like just invaluable trainings that you're making available. It sounds like basic, fundamental concepts that need to be understood by somebody who just got out of law school and is going to go out and try a serious, violent crime. And it's just, it strikes me that that would be something that is valuable and necessary, independent of views on policies like, for example, mass incarceration and things like that. When you're talking about baby prosecutor school, are you talking about just the fundamentals, the directs, crosses, examinations, how to introduce evidence, how to get witnesses into court, just that basic stuff? Is that right?
Yeah, that's part of it. We do have a smaller trial advocacy component in our basic prosecutors course. It's nothing like the 2.5-day seminar for DAs who've been in the office longer. But yeah, the trainings get into how to do your job. You know, everything from understanding the issues that you raised to also understanding, again, what's in Title 18, what's in Title 42. You know, somebody who just picks up the sentencing guidelines, you can call the Sentencing Commission. They're going to be extraordinarily helpful. But if you're in court, having a little primer at a training before is really going to help you to understand prior record score, offense gravity score, the grids, what enhancements apply, what's double counting, what's not. You need to know all of that. Because if you get it wrong, you might get reversed on appeal. Maybe we have to do a case law update at that point if it's a reported decision. So it's very important for everyone, for every assistant DA to understand those dynamics and that information.
And you've talked so much about the importance of collaboration, and I'd like to just understand a little bit more about what areas of collaboration and how you facilitate that collaboration, particularly between DA offices across the Commonwealth, so between the actual district attorneys.
So there are a number of ways that we foster collaboration. I think the committees that I've talked about, and there are some elected DAs on those committees, is one of the most salient ways that we foster the collaboration, because people are literally in the same meeting. We put out questions every week from both elected DAs and from assistant DAs. Again, questions that may be on case law, that may be about policy, that may be about issues that have come up. Elected DAs ask those questions, and assistant DAs ask those questions, and then we provide answers. But we send them out to the membership, so the answers so often come from members in the DA's office. Sometimes it's the elected DAs, and sometimes it's the assistant DAs. Elected DAs come to meetings and come to conferences, and we have meetings and we have discussions about various issues. So in all of these settings, in person and virtual and electronic, it is people literally talking to each other or figuratively communicating by email or by Zoom about so many different issues that occur.
Do you see a lot of open discussion if somebody, for example, disagrees with a policy or thinks that they're doing something that's working better for them? Do they share that information for the benefit of everybody else?
Yes. I don't think you're going to get in any association on any issue a group that agrees on, where the individuals agree on everything. We strive to operate by consensus, but not everyone agrees with everything. I think it would be shocking if I said that everyone agreed on everything. There are areas of consensus. There are a lot of areas of consensus. But when there's disagreement, that's healthy. And that's where really important conversations occur, just as what may occur in the General Assembly, what may occur in the private sector, where people sit around and they disagree, and sometimes you come up with a solution or a compromise, and sometimes you don't. But the conversations are respectful, they are engaging, and they are absolutely useful.
Do you have the numbers for how many trainings have been offered in 2022 so far?
So far, we are at about approximately 24 trainings this year, and we have had approximately 1,600 people register for the trainings.
I think you said that because they're not a member, none of the Philadelphia ADAs were registrants for those trainings, but historically, have those trainings attracted ADAs from the Philadelphia District Attorney's Office?
Prior to that, yes, some of the trainings were attended by members of the Philadelphia DA's office.
And when you say prior to that, you mean prior to them withdrawing from membership?
Prior to 2018, yes.
So in addition to getting registrants from that office, did you pull ADAs or even the DA or any staff members to do trainings for the Institute prior to the withdrawal?
Yes.
Okay. What sorts of trainings would they conduct, if you remember?
Now you're challenging my memory, but there may have been trainings on case law, new rules from the case law. Search and seizure certainly has come up. Now you're, as I said, you're making me go back six years, so I can't remember it exactly. But I think in the area of domestic violence, we've seen some trainings as participation as well.
And were there ADAs who were members of committees?
Mm-hmm. Yes.
Were they in supervisory positions, chiefs, supervisors?
Yes.
And there aren't any members who are, or any ADAs that are members of committees now at the association, is that right?
Correct.
From the Philadelphia District?
Yes, correct.
Okay. So I want to go back a little bit to just a general concept of what the PDA and the PDAI offer in terms of the training for the new ADAs. Is there any mandatory training statewide across the Commonwealth?
No.
Okay.
Other than the general CLE requirement for all attorneys, there's no mandated training for prosecutors.
For prosecutors, okay.
Correct.
Are you aware of whether there's any mandatory training in other states for prosecutors?
I think Georgia has mandated a mandated multi-hour training requirement for all of its new attorneys. And then for the prosecutors, they are required, instead of doing that, to do I would assume it's a version of a basic prosecutor's course. I think some other states may have some more narrow, quick hit trainings that are required, but Georgia is the one that comes to mind. But I've certainly not done an exhaustive 50-state survey.
And as the executive director, is some level of mandatory training for new prosecutors something that you think would be beneficial in the Commonwealth?
I think understanding the challenges of trial terms in different counties, and that they are not always on the same week, and the challenges of scheduling plus any costs to us as well as to the counties that would send their people there. If there's an understanding of that, that is certainly something we would absolutely work with whomever would be interested.
And I have no further questions for you at this time. I'll yield back to you, Mr. Chairman. Thank you.
Thank you, Ms. Decker. I'll recognize Representative Brown for questions.
Good morning.
Good morning.
Thanks for being here today. So I'm gonna bounce around a little bit. Some of the questions that I had were answered, so thank you. So whether you agree with this committee or not, do you believe that members on this committee should reflect what Philadelphia, or what's going on in Philadelphia, or victims of crime in Philadelphia? So basically, me being from Philadelphia, black man from Philadelphia, do you believe someone should be on this committee?
If you can restate, I'm sorry, I just am not sure by the question.
Got you. So would you agree,
Yeah.
whether you agree with this select committee or not, that a member or two should be from Philadelphia?
Yes.
Thank you. Is it safe to say that I'm an elected member of the House of Representatives?
Yes.
Thank you. Is it safe to say that I'm a resident of Philadelphia?
Yes.
Is it safe to say that I'm a registered voter in the city of Philadelphia?
To the best of my knowledge, yes. I am a lawyer, so I have to preface that answer.
Is it safe to say that I'm African American?
Yes.
Gotcha. Is it safe to say that young African American males and females are dying in our streets of Philadelphia?
Yes.
Thank you. Are you a resident of Philadelphia, sir?
I am.
How long have you been a resident of Philadelphia?
Since 1997.
Oh, you've been here a long time. Are you familiar with the violent acts that are going on in Philadelphia?
Yes.
Do you live in West Philadelphia or do you live in South Philadelphia?
I live in Center City.
Oh, Center City. Okay. Do you believe that violent acts are happening in West Philadelphia and in Center City?
So I read the newspaper, I watch the news. It appears that there are violent acts throughout the city of
All
Philadelphia.
over the city, right? Okay. Do you believe that the people committing these violent acts are first-time offenders or are they repeat offenders from your personal, professional experience?
I would surmise, and I actually think this is going to be the case throughout the Commonwealth, that you're going to have both.
Okay. So in your personal experience, you say you were with the DA's office formerly, correct?
Yes.
What percentage of the violent cases were repeat offenders? Can't remember?
That I don't know.
Okay. Do you believe that these acts are being committed by gangs or just random individuals or both?
I have seen in the press very reputable criminologists and others who have said both.
Okay. I'm going to switch gears a little bit. Are you familiar with the bail system and how it works?
Yes.
So can you educate me and the public on the bail process?
A bail can be different in every in each county, but generally speaking, except if you have, and I am not an expert in bail, but I'll give you what I know. Unless it is a certain higher level homicide type crime, you are eligible to receive bail at a bail hearing, and you typically would put up 10% of that amount, and there may be conditions imposed on you during your release on bail.
Okay. So in your experience with or witnessing bail hearings, if a high bail was requested and then the defense requests a lower bail and the lower bail is granted, how often do you believe, or I'm sorry, what's the process after that? Can the ADA or the representative from the DA's office appeal that decision?
I believe that decision by the MDJ or in other counties or the bail magistrate here can be appealed.
Okay. So if I, just hypothetically, if I attempt to murder someone, I shoot up a street corner with innocent women and children just walking down the street. Someone gets shot. I get caught with the firearm. I get take to the district, and then I go to my bail hearing. And it's requested a little under $1 million bail. But then the defense attorney requests a $20,000 bail. I get the $20,000 bail granted, I'm out on the street. Is that okay?
Look, every case is going to be different, and I think it's important to look at every case and look at the facts and circumstances. I don't want to make a generalization about what should happen with regard to every crime. What I can say generally is that magistrates and prosecutors around the Commonwealth in every county, need to take seriously the facts and circumstances about the case, the issue of victim safety, whether there's a belief that the defendant is going to show up at trial, and then an appropriate decision from that analysis needs to occur. But that analysis, that multi-level analysis, needs to occur in every case.
So do you believe that that decision should be appealed by the ADA?
Again, not knowing the specific case, I don't want to speculate, but I believe if in any matter, if a prosecutor believes that a judge or a magistrate has made an incorrect decision, and there's an appellate there's a remedy to appeal, you ought to consider appealing, whether it's bail, whether it's a motion to suppress, and whether you lose a case in Superior Court and you want to go en banc or file a petition with the Supreme Court. If that remedy is available, prosecutors should take a look at what remedies are available to try to seek justice and do right by victims.
Thank you.
Thank you, Representative Brown. Representative Thomas, you are recognized for questions.
Can you give me a job description of an ADA?
My short answer would be no. I mean, I can give you, I will.
A general one.
But I want to say, and the reason I just sort of glibly said no is because ADAs do so much in different areas. You might have an ADA who works the mental health court and the veterans court and works in the reentry coalition. You may have another ADA who tries homicides or tries sex crimes. And you have.
Do you hire specifically, so that's all they're going to do? So the job description would be that specific?
Every 67 counties, so every DA's office is going to be different. Some have people who are non-specialists, who just sort of do everything that comes in. And in some of the smaller counties, you see that. If you have 3 ADAs, one of whom is part-time, you're all doing everything that comes in. Now, somebody like the elected may have been a prosecutor for 15 years, so they may do the homicide. But in that smaller county, sometimes you're drinking from a fire hose. You're doing DUIs and you're doing aggravated assaults. In other counties, you have specialty units. Some counties have prosecutors who focus solely or for the most part on special victims. So rapes, abuse against the elderly, child abuse. You have some who specialize in homicides, and then you have firearms experts in other counties as well. And then you have appellate folks. So you have some offices where you have people who, for the most part, do appeals. They may help with motions and give advice within the office because they know the law and they know the case law, and that's a really, really important function. So when I said I can't give you a job description, I say that again rather glibly because, of course, I can give you a job description, but ADAs do different things in different offices. Ultimately, their mission is to seek justice and to do the right thing for the right reasons and act in an ethical and professional manner.
So I have a couple other questions. I just want to note, since you mentioned human trafficking earlier, it's a particular interest to me, and we passed several new laws last session to make sure that the victims were not the people being prosecuted. Did your association do any training or put out information on that?
We have done trainings on human trafficking, yes.
It is a significant problem, not just in southeastern Pennsylvania, but across the state.
Yes,
I'm
I
glad
can
to hear that you
absolutely
did that.
attest to this is
Thank
a
you.
Commonwealth-wide problem.
Small side. Does your organization advocate for change? So if the DAs feel that there's a law that's not helpful in providing justice, do you do advocacy?
Yes.
And who do you advocate to?
The General Assembly, the executive branch, If there are issues or policies within administrative agencies, we'll advocate to the corrections secretary or his staff or the parole board. So all of the above.
Is it safe to say that DAs in your association disagree at times with laws the General Assembly and the governor has signed?
Yes.
And what would you say is a DA's primary method if they believe a law needs to be changed in the state of Pennsylvania? What would be their best avenue to make that happen?
I think there are actually a couple of different ways of doing it that are effective. One way is to reach out to his or her state representative or state senator and say, "Hey, Representative Thomas, I've got an issue with this law. This law that passed 5 years ago, it's too narrow. We need to expand it to help victims more." And that's actually an example of, just to give you a flavor of how that works, of laws that might be too narrow. Years ago, we all worked together and got a bill through that allows experts to testify about victim behavior when the underlying crime involves a sexual assault. Absolutely necessary law, because victims do not all think alike and they do not all react alike, and it is sometimes counterintuitive how victims react. I believe it was last session, we expanded that, and you all voted for it, thank you, to expand that to cover domestic violence and human trafficking. So how does that work? I have DAs and ADAs who say to me, "Hey, Greg, that law, we need more. We need to cover domestic violence and human trafficking." And I say, "You're the third person to tell me that." And I may then reach out to members or both of the judiciary committees and or the DA in counties may say something to his or her senator or the state rep. You can do either, you can do both, but sort of that communication is how it typically works.
If I'm a DA and I disagree with a law, is it within my prerogative to not enforce it? Or prosecute it, is what I should say.
DAs wield a wide amount of discretion, and I think it's appropriate for DAs to utilize the laws as they see fit, so long as it's done in a way that that achieves justice. So it's hard to argue in a vacuum that question, but I will say that prosecutors need to look carefully at the facts and circumstances of each case, and to see if the facts of the case give rise to an action that ought to face consequences based on what's in the law. Some may disagree about that, and there may be disagreements based on different areas or issues, but it is absolutely critical to look at each case individually and make an individualized determination.
But that determination should be on the value of that case and an interpretation of a law, not on a blanket disregard for a law they don't happen to agree with.
I'm going to say that's a conclusion I don't want to jump into, but I want to say that it's important for staff, for ADAs and electeds to look at what happens in their cases and to make that determination based on the facts and circumstances and effects on victims and effects on their community and effects on public safety. That's why they were elected.
That's helpful. Thank you.
Thank you, Representative Thomas. Representative Ecker, you're recognized for questions.
Thank you, Mr. Chairman. Thank you, Mr. Rowe, for being here, as always. At the outset, you represent the district attorneys across the state. Would you agree that district attorneys, the elected district attorney, is a civil officer subject to uphold the laws of this Commonwealth and subject to the PA Constitution?
Yes.
So we talked a lot about trainings and the valuable trainings that you offer, and we spoke briefly about how the Philadelphia District Attorney's Office, which is the only office which is not involved with your organization, withdrew, I think, in 2018. was there a reason that there was a withdrawal? Could you explain just a little bit what happened there?
Yeah, at that time, the DA had said that he believed that our policies were, the policies we supported were too punitive and relied too much on incarceration.
Well, Mr. Rowe, you kind of ran through a lot of the trainings you provided, and from my perspective, it sounded most were more of an educational. Here's the law, and excuse me, and a change in law, or here's an XYZ crime. It didn't seem really focused on the punishment aspect. It seemed more of how to handle cases in certain areas.
I disagree with that. I think, for example, the presentation on the sentencing guidelines, that's all about
Fair
sentences.
enough.
So that the entirety of that is all about the sentences. But part and parcel to achieving justice and to appropriately securing a conviction, and part of that is what is the appropriate sentence. So those issues absolutely do come up as part of the training.
Perhaps I should ask another way. Obviously, every district attorney's office across the state of Pennsylvania operates in a different fashion. Your organization isn't there to suggest a proper way. It's more or less this is the law and recommendations or best practices, and then those district attorneys' offices then take that back and use it as they wish.
That's correct. In fact, we can't tell offices how to do their job. We're an association. We're not. We're not a district attorney's office, so we can, as you said, provide the best practices, provide the information, provide the guidance, and provide the collaboration amongst members of the office to share information and share experiences.
So outside of not having these trainings, your trainings, is there any other entity out there that provides said trainings that you're aware of as it pertains just to prosecutors?
Right. So I have no idea what one way or the other the trainings in Philadelphia, but I do know there are national trainings. So, for example, the National District Attorneys Association provides trainings. We work with the NDAA on lots of issues. The Association of Prosecuting Attorneys does some trainings as well. They're nationally focused, so they are a little bit different, but our members do partake in some of the trainings that those two national prosecutor organizations offer.
And just to reiterate that, but you work closely with that organization as well, or you have
we have a very good relationship,
relationship.
with both. We have one of our DAs is on the board of the Association of Prosecuting Attorneys and the NDAA, so very good professional relationship with both.
Nothing about your trainings are politically motivated. It's just providing a training to a district attorney's office that is, again, giving updates on case law or a field of study that particular office is going to handle.
That's correct.
You've mentioned you live in the city of Philadelphia, and I've referred to some press stories as it pertains to Philadelphia. There's folks that have acknowledge that they've worked in the DA's office or have left the DA's office for whatever reason, and one of the things they've mentioned is some of the training that or lack thereof of training at the district attorney's office. Have you heard those reports
About the trainings?
Just lack of training, at the district attorney's office in Philadelphia.
I haven't heard about a lack of training in the DA's office. I don't know one way or the other because I honestly haven't followed that.
Sorry, didn't mean to cut you off, Mr. Rowe. So presumably, when new DAs come into an office and they're not using your training, are you familiar with any training that's being provided in the DA's office currently, since they're not using your organization?
Right. So this would be third-hand information, so take it for what it's worth. I am aware, secondarily, that there continues to be a CLE program where, where ADAs are able to get their CLE credits and attend lectures. Beyond that, I don't know anymore. I'd have to suggest you contact the DA's office for that.
Very well. gonna change gears here a little bit. What are the code of ethics that district attorneys are held to?
District attorneys are lawyers, and they are subject to discipline from the disciplinary board for misconduct.
And that you're just to kind of hammer this home. This is the professional rules of responsibility.
Yes, rules of ethics, professional rules of responsibility, and there is a board that governs lawyers, which includes prosecutors, and they are able to and have sanctioned prosecutors, including former elected district attorneys, for malfeasance and other activities.
And this includes, for example, candor towards tribunals, duty to, provide certain information and ex parte communications, those types of ethics codes.
Look, I think their proceedings are not public. Their decisions are when they do suspend somebody or take away a license, they do publish them. So you'd have to take a look through those to see what the rationale was. But all the rules of professional responsibility are on the table. I just can't speak to why particular sanctions have been imposed in every case, but you can look at the rules of professional responsibility and things on the website for the disciplinary board to provide some of that information.
One second, Mr. Chairman. I think that's the end of my testimony. I appreciate your time, Mr. Rowe, and thanks for being here.
Thank you, Representative Ecker. Greg, I want to thank you for being here today and taking questions. So, having served in the General Assembly for 12 years now, I think I can say with a degree of confidence, it's challenging to be a legislator, right? You face issues across the board. We might be voting on bills dealing with, education matters, charter schools, veterans affairs, tourism in the state, criminal justice, all on the same day. And I can tell you, as a legislator, often many of my colleagues really value the input. It's not certainly the sole consideration of how they might vote one way or the other on a piece of legislation, but they value the input of the statewide organizations. So, for example, if we were going to move legislation that would affect the second-class township code, for example, the views of PSATs on that matter, would make a difference. A lot of my colleagues would want to know, where's PSATs on this bill? Maybe they'd agree or disagree, but they at least would want to know, right? If we were going to move legislation dealing with bonding for grain dealers, all right, the views of the Pennsylvania Farm Bureau, they would be of interest to members of the House. It might not be the sole reason they vote one way or the other, but we'd want to know. Same thing with the District Attorneys Association, and you've mentioned today your advocacy before the General Assembly on specific issues and specific bills, and I remember the bills that you're talking about, and these were generally the bills that you've spoken about, the policies that have been changed, the laws that have been changed. There was broad consensus on these bills. These were not partisan issues or party line votes. These were issues that generally passed with broad bipartisan support, and there's an interest in getting it right because it's important to get it right on these types of issues. You're talking about people's lives. And I think it's worth noting for the record that your organization can only represent entities that choose to be a part of it, right? So the largest, I think, am I correct in saying that the city of Philadelphia is certainly has one of the larger memberships when we look at how many ADAs are employed by the district attorney, the number of cases that are prosecuted, and so on and so forth. It's certainly the largest in the state. Is that correct?
Yes.
Certainly. So I think it's worth noting for the record that the largest potential member of your organization chooses not to be a part of it and have their voice heard on these, I would call them weighty matters. So in your experience, just a couple questions. In your experience, I'm sure you've dealt with assistant district attorneys over the years that have come in for training who have been part of a district attorney's office for decades. And I'm sure you've had folks who have, kind of come right in. Maybe they've been there for a week, right? You've dealt with, I'm sure, the whole gamut. Am I correct?
Yes.
So in your experience, new ADAs, folks who are just coming in to kind of signing up for the first time, do they typically come with robust decades of prosecutorial experience, or do they tend to be kind of right out of law school?
For the most part, they are right out of law school. There may be exceptions. There may be somebody who clerked. Some offices will hire laterals, but for the most part, they are right out of law school.
Right. So now, I've never been to law school. I'm not a lawyer. My understanding is that law school covers a pretty broad swath of material, right? So you have everything: contract law, wills, trusts, estates, divorce law, patent law, all sorts of different. And certainly you can specialize in particular areas. And every student, certainly their experience is going to vary. But again, in your experience, someone who's hired as a new ADA right out of law school, do they have an extensive degree of prosecutorial knowledge?
Other than perhaps a clinic, and there are individuals, some of the law schools offer clinics, that may run the gamut of the experience.
Okay. So you talked about some of the robust training that your organization provides. For example, you mentioned bias, right? So you talked about there's implicit bias. You talked about different, bias. You mentioned that earlier. Could you expand maybe just a little bit on that, on the concept of bias? What risks exist if an ADA gets it wrong when it comes to that?
You don't want to take an action based on an inappropriate perception of another individual, based on race or gender or class, or orientation or gender identity, among other things. So one of the biggest, I think, benefits of a training like that is the first step is understand we all have biases. And we don't need to hide behind it. In fact, we can't hide behind it. We have to acknowledge that we have that. That's okay, as long as we acknowledge it. And a training which sets that out there, and our training was done by a former prosecutor. That's really important. And then the question is, what are you going to do about it? But to do something about it, you have to recognize it first. And in a courtroom where lives are at stake, where somebody's liberty is at stake, and when there's a victim involved, you got to get it right, and you got to understand your own biases, your own strengths, and your own weaknesses in order to do justice and to do the right thing.
Now, you mentioned in your testimony about getting reversed on appeal, right, for not understanding perhaps sentencing guidelines. So that, with due respect, and I don't mean this rudely, that is kind of lawyerese, right? When somebody who's watching at home might hear, reversed on appeal for not understanding the sentencing guidelines. Maybe you could expound a little bit on that. Why would somebody get reversed on appeal? Why would a particular case be reversed on appeal because somebody didn't understand sentencing guidelines?
So if I get anything wrong, Mr. Bergstrom is next, and he is the expert on sentencing guidelines. So I'll preface it with that. But if there's a sentence, let me give you an example. So, and without getting into too much, and any appellate folks who are watching might disagree with you, Mr. Chairman, about about the importance. But in all seriousness, if a judge goes outside of the recommended range, he or she is supposed to state on the record the reasons for departing. Let's say, for instance, the judge doesn't do that, and nobody in the courtroom says, Your Honor, what are the reasons? It's just a blanket, I'm going to give you X, and that's higher than what's in the range. You're not following the law. The judge would not be following the law in that instance, and an appellate court may order a brand new sentencing hearing. What you might see more typically is, for example, something that was seized. The question is, was it seized lawfully or unlawfully? And as an ADA, you need to know when you look at the police report and work with the police, what happened, because you may put it into evidence, and if on appeal, the claim may be the conviction should be reversed because that key piece of evidence was illegally seized by the police from the defendant. If you're in the courtroom, you need to know. You need to know what's proper and what's not, because if If your conviction is as a result of that evidence, which was illegally seized, you're likely going to be reversed, and it's going to be hard to argue harmless error. Just two examples of where a reversal could occur.
Yeah, so I think everyone in the room would agree that there are many different types of procedural errors that could potentially occur as one's walking through really any part of the justice system, particularly in trial phase. So to be clear, if an ADA makes even a basic procedural error, couldn't that result in a case being entirely dismissed?
It could, yes.
So it seems to me, and this is my opinion now, I'm not going to ask you to comment on this. It seems to me that if you fire dozens of seasoned ADAs and replace them with new folks, perhaps right out of law school, and then fail to provide them with the training that's recognized as the gold standard across the entire Commonwealth, you run a real risk of rookies making basic procedural errors. Now let me ask you this question. If someone were to commit a violent crime, maybe there's witnesses, maybe there's videotape, maybe there's DNA evidence, but if there's a basic procedural error made, could not the case be dismissed and the individual who committed the crime be released to the streets?
That could happen, yes.
Very good. I have no more questions. Do any other members of the committee have questions? Mr. Rowe, again, I appreciate your testimony before the committee today. With that, the committee will recess for 5 minutes, and then we will come back to hear our next testifier. The committee is in recess. The committee is now going to take testimony from Mark Bergstrom, Executive Director of the Pennsylvania Commission on Sentencing. Mr. Bergstrom, I appreciate you being here today. You're already standing. I appreciate that. If you could raise your right hand to be sworn in. Do you swear or affirm that the testimony you are about to give is true to the best of your knowledge, information, and belief? If so, please indicate by saying, I do.
I do.
You may be seated. Thank you for being here today, Mr. Bergstrom. You are recognized for opening remarks.
Thank you, and good morning, Mr. Chairman and members of the committee. My name is Mark Bergstrom. I am the Executive Director of the Pennsylvania Commission on Sentencing. The Commission is an agency of the General Assembly. We were created to promote an effective, humane, and rational sentencing policy. The Commission achieves this through the adoption of guidelines for sentencing and parole, and through the establishment of a research and development program which serves as a clearinghouse and information center to support data collection and analysis, to conduct studies and evaluations, and to provide education and technical assistance. Thank you for providing this opportunity to testify regarding House Resolution 216 and to discuss the findings and recommendations related to House Resolution 111 of 2021, which required the Commission to conduct a thorough and comprehensive study of the investigation, prosecution, and sentencing of violations of Pennsylvania's Uniform Firearms Act. I will be referring to PowerPoint slides throughout the presentation, both during my testimony and then sort of a deeper dive. Hopefully I'll be working with staff back here to advance the slides, and at this point I'll ask them to advance to the next slide. There we go. Thank you. So House Resolution 111 directed the Commission to investigate 6 key areas: cases in Pennsylvania that involve firearms offenses, instances where firearms offenses were withdrawn or dismissed, sentences imposed for those convicted of firearms offenses, sentence recommendations for those charged with firearms offenses. Next slide. Rearrests for firearms offenses or violent offenses for those previously charged with firearms offenses, and violation of probation or parole for those convicted of firearms offenses. I've been asked to provide a brief overview of the Commission's H.R. 111 report submitted to the House of Representatives on June 30th of this year, and to specifically address the attrition of firearms cases, which is the part of the study that tracks the processing of firearms charges from the initial filing through final disposition. And because both H.R. 111 and H.R. 216 specifically address firearms offenses in Philadelphia. I will highlight the attrition of firearms cases in Philadelphia, often referred to as the county of the first class, as compared to other classes of counties. And the reason we do the comparison with other classes of counties or with a statewide average is just to provide some context. As I hope is clear in the H.R. 111 report, attrition occurs at various stages of the criminal justice system and may involve a reduction or elimination of charges and/or a conviction or plea to lesser offenses and/or acquittal of charges and/or a mitigation of sentence. Attrition may result from the exercise of discretion by various decision makers, or it may reflect initial charges that could not be proven at trial. It should also be clear that the H.R. 111 report reflects statewide analysis with a breakout by county class, not a detailed analysis at the county level. Next slide, please. As context for discussion of attrition, I have a case flow of the criminal justice system prepared by the Bureau of Justice Assistance. The graphic identifies key phases and decision points as a case moves from the initial contact with police through the release from the system. Next slide. The first phase, entry into the system, focuses on the role of law enforcement and decisions related to arrest. Next slide. The second phase, prosecution and pretrial, involves decisions related to the filing of charges and the disposition before the minor courts. In Philadelphia, that would be before the Philadelphia Municipal Court. In the rest of the Commonwealth, it would be magisterial district judge courts. Next slide. The third phase, the adjudication, applies to cases bound over to the Common Pleas Court for trial or formal disposition. Next slide. And the final phase, sentencing and sanctions and corrections, address post-conviction options and procedures. Next slide. The first directive of House Resolution 111 to identify all cases that involve a firearms offense also provides useful context. Chapter 61A of the Crimes Code, or Title 18, often referred to as the Uniform Firearms Act, includes 17 specific offenses that range from a felony of the first degree, which would have a maximum sentence of 20 years, to summary offenses where the maximum penalty is not more than 90 days, and include one specific offense to Philadelphia, Section 6108, which relates to carrying firearms on public streets or public property in Philadelphia, which is a misdemeanor of the first degree. Next slide. In this report, charges for firearms offenses are often referred to as VUFA, or violation of the Uniform Firearms Act. The analysis of firearms offenses by the Commission considers three groupings. Next slide. Back up one. There we go. Three groupings. One is all VUFA dockets. So any docket before a court that included at least one firearms offense. The second is F1, F2 VUFA dockets. That would be a docket that included at least one prior felony 1 or felony 2 firearms offense. And then the final VUFA dockets co-charged with violent offenses, which is a case that included both a firearms offense and at least one violent offense. Next slide. And in H.R. 111, the House provided a definition of violent offenses, and this is the list of violent offenses. So whenever I'm referencing a docket or a case that included co-occurring violence, it would be that one of these offenses was also charged or convicted in that incident. Next slide. Firearms offenses are included in 3.8% of all non-summary dockets filed statewide in the lower courts during the study period, which was 2015 to 2020. So 3.8% of all cases in the Commonwealth, all dockets for non-summary offenses, included a firearms offense. Of that, 1.6% of all non-summary docket cases included a felony 1 or felony 2 VUFA offense, and less than 1% had the co-occurring crime of violence. In Philadelphia, as comparison, dockets containing VUFA charges accounted for 9.4% of all non-summary dockets filed in municipal court, with 4.7% for F1 and F2 VUFA dockets and 2.2% for VUFA dockets co-charged with a violent offense. As discussed in detail in the report and highlighted in the PowerPoint slides that will follow, the Commission found that serious gun violence is typically concentrated in more densely populated areas, meaning that the patterns of arrests, court filings, prosecution policies, and sentencing practices may vary based on urban versus rural characteristics of a county. Other factors may impact the processing of cases, including police coverage, such as part-time versus full-time officers, single versus multiple departments, or coverage area, and local rules. That is, approval of the level of approval of charges by the district attorney. In the H.R. 111 report, the Commission uses county class to document and compare practices related to processing firearms offenses. While population density may vary among counties in each class, the average population density of a class grouping used in this study is associated with class size, increased with class size. And if you look in the handout on attachment B, it's a listing of all the counties, and they're grouped by county class. And included there is not only a listing of the population, but perhaps more importantly, the density of the population, because that seems to be an important factor. And as is I guess obvious, Philadelphia, the county of the first class, has the largest population at 1.6 million and has a population density far greater than any other county in Pennsylvania, population density of 11,937 per square mile. The next in line as far as population density is I believe Delaware County with 3,138 per square mile. Since Philadelphia County and Allegheny County, Class 1 and Class 2 counties, have unique county assignments, that means they are individually in each of those county classes, it is possible to compare these counties with each other and more generally with other classes of counties. In some cases, Philadelphia and Allegheny counties share common features that separate them from all other counties, while at other times their practices differ from each other. Some explanations may be found in the structure of law enforcement. In terms of Philadelphia County, there's generally a single jurisdiction, the Philadelphia Police Department, whereas in Allegheny County, there are 130 municipalities in the county and 109 separate police departments. Also, local rules could impact differences between Philadelphia and Allegheny. In Philadelphia, the district attorney reviews all misdemeanor and felony charges before filing, versus in Allegheny County, the screening is limited to homicides and sex offenses. So there's quite a difference between what is determined by the police and what is the filing at the lower courts. You'll find the listing at attachment C of all the counties and the local rules. And as you'll see, in 27 counties, there is no requirement of the DA to review charges before filing. In 7 counties, including Philadelphia, all charges must be reviewed by the district attorney before being filed. And then in 33 counties, there's some subset where the DA reviews those cases. Before turning to the PowerPoint slides, which will provide greater detail on several of the findings, I wanted to give you some high-level or general findings from the report. Number one, a higher proportion of VUFA dockets, or dockets with firearms offenses, were withdrawn or dismissed in lower courts in Philadelphia and also in Allegheny County as compared to the statewide average. Philadelphia is 17%, statewide average is 12%. An increasing proportion of VUFA dockets were withdrawn, dismissed, or null prossed in common pleas courts in recent years in Philadelphia as compared to the statewide average. And there was an increase over time from 7% up to 21% over the various years reviewed. And then finally, individuals initially charged with VUFA offenses were charged with another VUFA offense within 3 years at a higher rate in Philadelphia, 29.5%, as compared to the statewide average, which was 20%. So I'd like to move to the slides and start to walk through some of the details from the HR 111 report. And as I said before, I'll try to focus primarily on the impact in Philadelphia, which is listed in these slides as the county of the first class. So thank you. We'll start with this slide, which just to provide a bit of context, if you considered all the charges filed in the Commonwealth for the period of the study, 2015 through 2020, there were 1,355,687. Of those, firearms represented 3.8% of the dockets. In Philadelphia, as I said, the firearms represented 9.5% of all cases. 4.7% were F1 and F2 dockets, and 2.2% were co-occurring violence. When we look at this starting point, this table, the starting point is how many charges were filed in municipal court for Philadelphia that included firearms offenses. How many dockets were filed? And you'll see the number listed is 18,026. So that's the starting point of our analysis of what we call attrition. These are cases that were filed in municipal court that included a firearms offense. And what the commission was trying to do was just track those cases through the system and determine if they remained in the system and led to a conviction and a sentence, or if they were removed in some way from the system. So we're just tracking the movement of the cases through the system. Next slide. This provides a little bit of a table where you can see some of the details of the numbers of cases. So for the first class county for Philadelphia, 18,026 cases, which represented 34.9% of cases statewide that included firearms offenses. And then you'll see that as we move to F1, F2 dockets, 39.8% of all dockets in Pennsylvania with F1 or F2 VUFA offenses were in Philadelphia. And then we move to VUFA dockets co-charged with violent offenses, and you'll see the percentages up to over 50%, 51.4%. Next slide. As we review all of the dockets filed and try to get a sense of which firearms offenses were included, we found that the four most common types of offenses were 6105, person not to possess, 6106, firearms not to be carried without a license, 6108, that offense that's unique to Philadelphia, which deals with carrying firearms on a public street, and 6111, sale or transfer of firearms. And when we looked at the grading of those offenses, 24% were M1s, 40% F3s, 22% F2s, and 7% F1s. So that gives you some sense of the numbers. There have been some questions, I guess, raised about the role of 6108. Since that is an offense that can only be charged in Philadelphia, does that in some way inflate the numbers in Philadelphia? But we did look at that, and we did the analysis where we removed 6108 and looked at the remaining dockets. And what we found was, in removing 6108, of the Philadelphia cases, the 18,026, when we removed 6108, it only removed 92 cases. So that was under 1% of the cases. And it really had no impact on the percentage of cases dealt with by Philadelphia versus the other counties. So although it is something unique to Philadelphia in terms of that charging, it really didn't have much of an impact in terms of numbers or attrition. What I think we found was in most cases when 6108 was charged, there was another firearms offense charged in Philadelphia. So as a result, that case remained in the system. Next slide, please. So this is just a graphic to show you the comparison of Philadelphia, certainly with other counties and classes of counties, but I think more importantly for this discussion, just a comparison with the statewide average. So you see the dark line is always the statewide average, and the line right below it is the county of the first class, so that's Philadelphia. You can see substantially higher in terms of the number of dockets per 100,000 population in all three categories, for all dockets, for dockets where F1 or F2 VOOF is the most is included, and dockets where there's a co-charge with a violent offense. Next slide. We're going to move to a discussion of the processing of cases in minor courts. So if now we have these filing of cases, the question is, how does the case make it through the minor courts and off to common pleas, or is it resolved in the minor courts? And so this is a graphic that tries to get to that. If you start with municipal court and you see that there were those 18,026 cases, the first thing we have to recognize is that there may be cases that are still in the process, that they're pending cases. So in this case, there were 17% of the cases in municipal court were still pending when we were doing the study, and that accounted for over 3,000 separate dockets. Now you can think about the reason why cases may be pending. For instance, we did the period of time was 2015 through 2020. So the cases just filed in 2020, think of a sixth of the cases, it's reasonable to think they'd be pending. But one thing the other thing I guess that's obvious that I should point out is 2020 is when COVID started, so there's COVID impacts, and clearly COVID impacts in the Southeast that may be different than other parts of the Commonwealth. So I think those are important factors in terms of why there might be pending cases. But nonetheless, as compared to all other counties except Philadelphia, the pending rate in cases in municipal court were 17%, and all other counties, the rate was 6%. Next slide. And this just provides the details of those numbers regarding the dockets that were in the lower courts. Next slide, please. So the analysis of attrition focuses on cases where there's a disposition in lower courts. So we're going to look at a couple of different things. If we just focused on those where there's a final disposition and they're not pending, you'll see that there's cases that might have been dismissed, cases that may have been withdrawn. There may be other issues in play, local practices that account for some cases sort of falling out of the system. There may be cases resolved where the MDJ or the municipal court has the authority to dispose of those cases, so they might be there. And then the final thing is, what are those cases that are bound over common pleas court, bound over for trial? So those are the sort of distinctions we're looking at, and again, we're comparing municipal court and Philadelphia to the rest of the state, because everywhere else in the state are the MDJ courts. And so you can see from this graphic that the bind over rate generally is 81%. In Philadelphia, it was about 80%. In the rest of the state, the bind over rate was 82%, so Philadelphia is a little bit lower. But there is a real sort of mix in terms of comparing Philadelphia to the statewide average regarding the distribution of the processing of the cases. Next slide. So you'll see on this slide, Philadelphia County is highlighted, and it's right below the statewide average. So the statewide average for all VUFA cases 10% in Philadelphia, 10% were withdrawn. The statewide average is 8%. For dismissed in Philadelphia, it was 7%. Statewide average was 5%. And then you can see for other and resolved in lower courts, sort of flips where the statewide average is higher. But overall, we're getting to about the same point in terms of the bind-over rate of 80 versus 81%. As you move down, though, you'll see that this may differ somewhat as you look at the cases that are more serious cases where felony 1 or felony 2 VUFA charges are included, or where there's a co-charge with a violent offense. So just some details there. You have it in the materials, and it's in our full report. So I'm not going to spend a lot of time except to say there's some variances in those kind of things. Next slide, please. But here I do try to look at the percentage of dismissed and withdrawn non-pending dockets in the lower court for all VUFA dockets. And so you can see statewide sort of the distribution by year. So remember, we talked about 2015 through 2020, with 2020 sort of being the start of COVID or a COVID-influenced year. And then you can see Philadelphia versus, in this case, Allegheny County. But for Philadelphia, the trend, at least in terms of dismissed and withdrawn cases, is sort of trending up until we get to the 2020 year, which is sort of you have to sort of put an asterisk by that because of the influence of COVID and because there's a pretty big percentage of cases that are still pending there. Next slide. We're going to now move to another phase of the system, the adjudication phase. So we're looking at the cases that were bound over from municipal court in Philadelphia to common pleas, or in the rest of the state from MDJs to common pleas. Next slide. And you can see the numbers here. So we start with the bind over numbers, and you can see overall the number of cases that were reported before. One thing I want to point out, and I don't think it's reflected on the slide, but I think it's an important number. When we start with at the very top of the slide, you'll see under municipal court the 18,026 we talked about. That's the total number of filed cases. Sort of the next significant number is sort of in the middle where you see bound over for Philadelphia at 80%, and that's the 11,921. The thing I want to note here is those were cases bound over, but not all of those cases retained a VUFA offense. So think of someone charged with a bunch of offenses, and through the municipal court process, the case itself is bound over to common pleas court, but the VUFA count is removed from it. It's found not to be present, it's withdrawn, other things like that. So there's going to be a slight difference between the all cases bound over that started with a VUFA count and the cases bound over that retained a VUFA count that we'd then be tracking in common pleas court. So the difference in Philadelphia was there were 11,921 cases that started with a VUFA count bound over, but there were 10,974, so about 1,000 less, that were bound over that retained a VUFA count. And then of that, we're going to be talking about how many of those ended up in a guilty finding and what kind of sentences were imposed. So next slide, please. So here you get just the breakout of the number of cases that were pending VUFA dockets in common pleas court. This is sort of the same issue that we talked about before at the lower court, that especially for the year 2020, there's going to be a bunch of cases that are still happening, so we're not going to be able to analyze those. We're going to sort of put those aside as pending cases, and we're going to focus on cases where there's a final disposition of the case. Next slide. So here's that mapping again, but we're going to focus a little bit more on what's happening at common pleas court. And you can see that there's a movement of cases, and you see the breakout generally from common pleas court of pending cases, 24% overall, and then dismissed, withdrawn, Null prost is a big category of 10% of cases statewide. And then others not guilty, and then about 83% guilty rate. So that's the general, if you look at all cases in the Commonwealth, that's sort of the high-level thing. Next slide. So if we want to break that down then and look specifically at Philadelphia versus the statewide average, here are those three categories again. So for all VUFA cases in statewide data, 83% end up in guilty pleas, 77% in guilty pleas in Philadelphia, 1% withdrawn, 0% in Philly, not guilty 3% statewide, 5% in Philly, and then null pros 10% statewide, 13% in Philly, dismissed 1% each, and others 2 and 3%. So that's the that's sort of the comparison for all offenses. And then if you go down and you look at when VUFA was a felony 1 or felony 2 was included in the case, you'll see there's a lower guilty plea or guilty rate in Philadelphia, 75% versus statewide 81%. And you can see the other figures as you spread across. The null pros rate is a little higher in Philadelphia, 15 versus 12%. And then when we look at co-occurring with violent offenses, you'll see Philadelphia is a little lower in terms of guilty pleas, 83 versus 86, and otherwise pretty similar to the rest of the state. So next slide, please. But one thing to think about is, what are the trends? And so what direction are we going during this period of time? So here's a breakout by class. So the first one is statewide, second one is Philly. So those are the two we'll end up focusing on. But these are the non-pending VUFA dockets from 2015 through 2020. Next slide. And just to make this a little easier, you can see each year has a different color. They're in sort of this order. So we want to sort of see the trends over time, and we want to also just keep in mind that 2020 is just a bit different because there's active cases and there's the influence of COVID. Next slide. So here's the statewide average. It's 83% guilty plea, and you can sort of see the band from below 90% to below 80% as you take year to year. It's sort of trending down. One thing you have to think about with the statewide trend is it includes all counties, all 67 counties. And so to the degree Philadelphia, Allegheny, or any other county is having sort of an outsized influence, it's going to be baked into the statewide average. It's not as if we're talking about Philly versus the rest of the counties. It's Philly and then Philly and the rest of the counties. So there, if you were just comparing Philly to all other counties, there might be a bigger divide because you'd be taking out the influence of Philly, and Philly accounts for, you know, a third of the cases at least when we're starting. So it has sort of an outsized influence in a statewide average. With that, next slide. So here's the sort of the listing of all those counties. You can see Philly is right next to the statewide one, and then you look at the other classes and you see that there's a different thing. So this highlights the second A, so the suburban counties around Philadelphia are the Class 2A counties, and then Class 3 counties. And then you can see it, and those have sort of the highest rate. And then the next is for the Class 4 through 8. Next slide, please. And then we get down to Philly and Allegheny County, and you see their profiles are different. Their averages are lower at 77 and 78%. Next slide. And then we'll look a little bit more specifically at Philadelphia. And again, Allegheny County is listed in this because they have some similar profiles to some degree. So 77, 78%. Next slide. And you can see that year by year, the numbers changing. And you can see in Philadelphia, they started 88% guilty pleas and dropped down in the last year to 66%. And even if you assume that the last year, 2020, is going to be influenced by pending cases and by COVID, you can see that there's just a trend in the direction regarding guilty plea cases. And the same general trend applies in Allegheny County, but not nearly at the same degree. So one thing that's different in Philadelphia versus other counties is just the sort of year-over-year trend in terms of the percentage of cases found guilty. Next slide. And then if we look at null pros cases, you can see sort of the trend in the opposite direction, an increase in the use of null pros cases. And we're seeing it, across the state, but, it's dramatically different for Philly and Allegheny County and substantially different, as you can see here, for for Philadelphia County, especially if you look through 2019. There's that, pretty big increase from 7% in 2015 to 21% when you get to 2021 or 2020. Next slide. So we're going to now move to the sentencing phase. And I know Mr. Rowe talked before about sentencing guidelines. I won't try to give you a primer on guidelines, but I will give you sort of an intro to it. So next slide. So this is the sentencing guideline matrix. And just as sort of a background, sentencing guidelines are intended to provide courts in the Commonwealth with a common starting point for sentencing. And it focuses on the current conviction offense, for which we use basically a 15-point scale. This shows 14 of those categories called offense gravity scores, with 1 being the least serious offense and 14 being the most serious offense. So it takes into account the seriousness of the current conviction offense. And then across the top from left to right is what we call the prior record score, but just think of it as criminal history. If someone had prior offenses, it's captured in an increased recommendation. And criminal history or prior record score take into account both the number and the seriousness of prior conviction offenses. So it's not that those numbers represent like 1 count each. It's that, a violent offense would be worth 4 points in the prior record score. So 1 violent offense would get you across to 4 and a higher recommendation. So just that, that's about 30 seconds of how guidelines work. But, it's sort of a crosstabs of these 2 factors, the seriousness of the current offense, seriousness of the criminal history, and the intersection of those is the recommendation. And the recommendation is a recommendation about the minimum period of confinement. So any of those numbers you see are in months, and they represent the minimum period of confinement. In Pennsylvania, we're an indeterminate system, so when judges are confining someone, they're giving both a minimum term and a maximum term. So the minimum term takes into account the guidelines and becomes that minimum sentence. People generally have to serve the minimum before being eligible for parole. And the maximum sentence is always at least 2 times the min, and it's the maximum period of supervision. So if someone is given a 5 to 10 year sentence, they're committed to the Department of Corrections. They serve 5 years. If they are paroled by the Board of Probation, by the Pennsylvania Parole Board, they are under community supervision under parole for the remaining part of the sentence, the 5 unserved years. If at any time during that period there's a violation, they're recommitted to continue serving that original sentence. So that's how our system operates, that minimum and maximum. So our sentencing guidelines focus on the minimum term that we're recommending. And as Mr. Rose said, courts are required to consider the guidelines for each and every conviction offense. And if courts go outside of the guidelines, we call them departures, courts are required to provide reasons for the record. Those reasons are subject to appellate review. So back to the slide with the matrix. I just gave you, sort of the recommendations, how they work. Let me describe conformity, because this is one way of sort of using standards to compare sentences by counties. Because if you take into account that the conviction offense has specific assignments in terms of the offense gravity score, and we have a system for determining the prior record score, then we have a consistent way of comparing county to county, regardless of how many counts they have. We're just looking at, did you stick within the guidelines based on these common principles or not? And so the way we think about the guidelines is if the minimum sentence given by the judge is within the recommended range, we call that a standard range sentence. And then if you look at the right-hand side, you'll see that orange column with plus or minus. That sort of describes aggravated and mitigated ranges. How many months on top of the standard range is available to the court to take into account aggravating factors? And then how many months below the minimum, the base of the recommendation, is available to the court to take into account mitigating factors. So if a judge gave a sentence below the standard range, but it was within that band, that plus or minus, that would be considered a mitigated sentence or an aggravated sentence. It's considered part of the guidelines. If the judge goes above the aggravated or below the mitigated, that's a departure from the guidelines. And that's where reasons are required, and that's where you see the appellate review that Mr. Rowe talked about. So that gives you a sense of when we talk about conformity, if you see mitigated, you know it's below the standard range, it might be a reason provided by the court. If it's below mitigated, it's a departure below. So we're looking sort of south of the standard range as we're talking about those things. And the final thing about conformity, we always talk about this in terms of the sentence being imposed by the court. But keep in mind, 95% of cases are negotiated pleas. And depending on the county, there are rules about whether the plea includes a sentence or doesn't include a sentence. So that's county specific. But courts cannot engage in negotiated pleas. They can only either accept the plea or reject the plea. So each county is different in how they do all of that. But I do want to stress that although when we talk about conformity and about sentencing guidelines, we talk about the judge's role in this. And the judge does have a huge role in this. When you have negotiated pleas, it's very possible that the parties agreed to a mitigated sentence, a departure below or a departure above. And there might be all kinds of reasons going into that, but there's many people that might contribute to that decision. So final part of this slide, and I apologize for all the time on it, but the final part is just an example with a firearms offense. So one of the firearms offenses is 6105, person not to possess. It's a felony 1 offense, so it has a 20-year statutory max. It's an offense gravity score 11 if the weapon is possessed and loaded. So if you look up at 11, you'll see the first column, 0 prior record score. The minimum sentence recommendation is a minimum term somewhere between 36 and 54 months. So let's say the judge gives a 48-month or 4-year minimum term, which would be in the standard range. If the minimum term is 4 years, the max would have to be at least 8 years. That's the structure of our sentencing in Pennsylvania. But because it's a felony 1 offense, the judge could go up to 20 years as the max. So a standard range sentence could be 4 to 20 years. And the person goes off to the DOC, and after 4 years would be eligible for parole. That's how our system works. So that would be an example of the OGS 11 for that firearms offense. So the standard range would be a minimum term between 36 and 54. Aggravated would be a minimum sentence somewhere between 54 and 66 months, and mitigated would be somewhere between 24 and 36 months. Below 24 months would be, or non-confinement like probation, would be a departure below the guidelines. So when we're looking at sort of sentences below the guidelines, mitigated or departures, sort of departure below is probably what we're talking about. The final comment I'll make on this slide is there were questions before about repeat offenders versus first-time offenders. Generally speaking, in Pennsylvania, about half the cases are 0 prior record score. And there are diversion programs, other things like that are outside of the guidelines. But for individuals coming into the court system and being sentenced under the guidelines, as sort of a rule of thumb, about half of them are 0 prior record score, and so the rest of them are spread across the record. Okay. Next slide, please. So based on now your total understanding of guidelines, Here is the conformity to the guidelines for certain VUFA offenses. So the first is all VUFAs, any docket that has a VUFA offense, and you'll see the statewide average, and I think I wrote down what these are because the numbers might matter. So at the top, for statewide average, the standard range, so we'll start in the middle, is 43% statewide, and for Philadelphia right below that, it's 28%. If you move to the left, the mitigated range, statewide is 27%, in Philadelphia 28%. And then to the far left, outside below, statewide is 25%, and in Philadelphia, 34%. So generally speaking, Philadelphia has, and you can see it graphically there, that Philadelphia is below the standard range and above the mitigated and outside below. And then if you look on the upper end, and these would be a smaller number of cases, you'll see Philadelphia sort of outperforms the statewide average both in aggravated and in departures above. So they're sort of more extreme in both directions, but the big numbers are in the lower part in the departures below or the mitigated range. So that's for all offenses. If we move to the next slide and we look at just dockets where F1, F2 VUFA is present, you'll see again the numbers, and I'll provide them to you. Starting in the standard range, the statewide average is 34%, Philadelphia is 23%. Mitigated range, statewide is 20%, Philly is 19%. And outside below, 42% statewide and 51% for Philadelphia. And then the next slide is looking at that co-charge with violence. If we start in the standard range, 51% statewide, 50% Philadelphia. Mitigated range, 14% statewide, 11% Philadelphia. And outside below, 21% for both Philadelphia and statewide. And at the upper end, you see Philly is, again, slightly higher than the statewide average in both of those categories. Next slide. So I'm going to close where I sort of started. I talked about the exercise of discretion by the parties and attrition. And I just wanted to point out some of the things that might contribute to this. One is, for prosecutors, they may withdraw or decline or pursue charges or decline to pursue charges, so null pros charges, due to circumstances that make it unlikely to succeed at trial. For instance, there was a bad arrest, there was an illegal search, something like that, or witnesses, including law enforcement, failing to appear for a hearing. Or it could be a change of jurisdiction. This is a case that was sent back to juvenile court, or it was a federal adoption case with firearms cases. We talked to the U.S. Attorney's Office in the 3 districts of Pennsylvania, and although there is federal adoption of firearms cases and there's collaboration between local prosecutors and federal prosecutors, the numbers, at least that we had, did not substantially influence this stuff, although there are clearly key cases that go federal. The other thing, as far as attrition, judges may dismiss a charge or a case based on speedy trial or due process claims, or because there's not a finding of guilt. Next slide. So I'm going to close by just returning to a couple things that the Commission found in the H.R. 111 study and included as recommendations. I started by saying that this study was intended to be, it was a 6-month study. It was a high-level, sort of statewide study where we looked at county impacts, but we certainly were not able to do a deep dive into county procedures. So here are some of the general recommendations. You know, the Commission recommended that there be more of a study at a county level, getting both what we call qualitative data and quantitative data. So much more data, for instance, in Philadelphia about what what is happening in law enforcement regarding initial contact with individuals and recommended arrests versus what happens in terms of filing. What's the difference between people that are charged or arrested and charges that are actually filed in court? We would need to know county-specific information to get to that. Next slide. We also wanted to take into account what we call qualitative information, like understanding what the procedures are internal to the prosecutor's office, other types of court proceedings that might explain why cases are being dismissed or withdrawn or null prost. Next slide. We think generally throughout the Commonwealth there's a mismatch of data. It takes a lot of work to prepare a data set and analyze the data. So efforts to try to think more comprehensively about how the Commonwealth, how this committee, how the General Assembly continues to study this area could be enhanced if there was just more attention to some of the ways of tracking cases through the system. So just better data. Next recommendation. And then finally, we think there are other things that influence how cases move, and especially from the court process. We did look a little bit at pretrial decisions about pretrial release, bail or pretrial release versus detention. There's a lot more work that could be done there, and there's really not very good high-level organization of that, so we made recommendations related to that. Next slide. And I have my contact information there. Let me close by thanking the committee for providing this opportunity, and because I think many of the recommendations in the HR 111 report probably are in sync with the work of this committee. I think it's important that the committee look at those recommendations and think about ways to improve the investigation, prosecution, and sentencing of VUFA charges in Philadelphia and throughout the Commonwealth. Thank you very much.
Thank you very much for your robust testimony. I have to say that that was very well researched and your presentation was fantastic. I'm going to turn to Mark Rush for questions. Mr. Rush, you're recognized.
Thank you, Chairman. Mr. Bergstrom, good afternoon.
Good afternoon.
I, too, would like to say that was truly very helpful, very granular. Granular data that certainly I think this committee can put to good use to try and find solutions to make the city of Philadelphia a safer place for the residents of Philadelphia as well as for those that visit here, and that is frankly why this committee is here today. So I thank you again for that data. I would like to simply follow up in a couple different areas because your presentation was very thorough. I'd like to return to about 30,000 feet to understand some concepts because I think those concepts can help inform the committee as it continues its work in investigating law enforcement and prosecution here in Philadelphia. And if I might direct your attention, and you can either refer to it or not, but it's page 4 of your prepared testimony, which I have in front of me. And specifically, it's the first bullet point on that page that begins with an increasing proportion. You see that point,
I do
sir?
see that.
I'd like to break that down a little bit for the members here in the audience as well as the committee. It says an increasing portion of VUFA dockets. Now, VUFA you define for us as the violation of the Uniform Firearms Act.
That's correct.
And it would be fair to say that the Uniform Firearms Act of Pennsylvania is the laws that relate to the illegal possession or use of firearms within the Commonwealth of Pennsylvania.
That's correct.
So they're the existing gun laws of Pennsylvania that are currently on the books.
Yes.
Is that fair? Thank you. And then you say here they were withdrawn, dismissed, or null crossed in common pleas court. And in recent years, I think your data defined recent years ultimately between 2015 and 2020 by about 30% in Philadelphia. Is that correct?
Yes.
Now, to understand what withdrawn, dismissed, and null crossed, I'm going to ask you to define them. Like, who has the ability to withdraw VUFA charges in a criminal case once they're filed?
The prosecutor.
So that's Mr. Krasner's office, is that correct?
Whoever is responsible in that office, but yes, that office.
Yeah, the office of the district attorney.
That's correct.
Okay. So, and the office of the district attorney is the one who would dismiss charges, is that correct?
That is correct.
And again, the office of the district attorney would null pros charges, is that correct?
That's correct. On the dismissal, it could be the court dismissing it too, not finding, evidence.
Sufficient evidence.
Yeah.
Fair enough. But there was an increase in those 5 years, I believe, of approximately 30% of those VUFA dockets or crimes charged were withdrawn, dismissed, or null prossed, either by Mr. Krasner's office or by Mr. Krasner's office in the court.
That's correct. We saw an increase year over year.
And those are the existing criminal charges that are available for gun crime violations, correct?
That's correct.
So it's been advanced or propounded by some, not a lot, but by some, that we need additional gun crime charges in the Commonwealth of Pennsylvania. But I would say that if the district attorney's office is dismissing 33% of the current laws that are on the books against offenders, I'm not sure how existing laws would help facilitate any change. I don't know if that's a question, but it was something that your data at least triggered in my mind, that question. I mean, do you have any thoughts on that?
Well, I've been at this a long time, and one of the things we've seen over time is there are a lot of laws on the books, and whether it's through law enforcement or prosecution or even the courts, the use of those laws can be spotty. And I know many years ago we had a concern about illegal possession of firearms, 6105, where there was an interest in having the General Assembly increase the classification of that crime. But what we found at the time was it was not being charged, or it was being negotiated away as part of a lot of proceedings, not just in Philadelphia, throughout the Commonwealth. And so one of the things the Commission at the time strongly recommended is use it if it's there. And before we start thinking about changing the law, let's make sure it's being used like with fidelity when possible, and then it's not being negotiated away. So that was a comment, decades ago, and I think that's still helpful to think about. I think the General Assembly has done a lot in recent years to enhance and provide more tools in terms of penalties available and increasing penalties, but they have to be used as well.
And used by the prosecutors.
By the prosecutors throughout the Commonwealth.
And we're going to get to charging decisions, how people are criminally charged in Philadelphia in a little bit, but I do want to touch upon your second point. And your second point, I think, captures what is of great concern to this committee, and frankly, of greater concern to the mothers we heard from yesterday and the other victims who we haven't heard from yet because of time constraints, or who we as a committee have interviewed in private sessions, and that is repeat offenders. So this second point here, it says individuals initially charged with a VUFA offense were charged with another VUFA offense within 3 years, and in Philadelphia at almost 30%, statewide approximately 20%. So my question on that data point, because I find it interesting, and that is basically a guy with a gun ends up being charged as a guy with a gun within 3 years, 30% higher here. Would those include, those individuals in your percentage, in your data points, include individuals that had prior gun charges dismissed or null prossed by the Attorney General, or excuse me, by the District Attorney's Office?
Yeah, I'd have to look closer at the data, but it should, because they would have been initially charged. So if the charges were filed, then yes, that's true. If the charges were, if an arrest was made, but the charges were never filed, it was dismissed before that, it might not show up in our data because it would have been excluded from the filing.
So maybe we will get more granular with you on that point, because I truly believe that it's important for us to understand if an individual was null prossed by the District Attorney's Office for carrying a gun, and then 3 years later he gets jammed up again with a weapon.
Yeah,
that
would be in our data, yes.
Excellent. Thank you so much for that.
You're welcome.
And as I promised to the chair and to the committee, I'm going to wrap up here. But I want to make one point that I think needs to be sharpened, that may have been not focused enough, and that was from yesterday's testimony. Here in Philadelphia, and correct me if I'm wrong, sir, it's my understanding, the committee's understanding, that all charges that are filed against individuals must be approved by the Philadelphia District Attorney's Office. Is that correct?
That's my reading of the local rule, yes.
So in other words, the Police Department of Philadelphia does not have the power to file a criminal complaint following an investigation without approval from Mr. Krasner's office. Is that correct?
That's my understanding, yes.
That would include violations of the Uniform Firearms Act, correct?
Yes.
So if a police officer arrests a man during the commission of a narcotics sale who's gunned up, who has a firearm, they do not have the ability to file a criminal complaint against that individual unless Mr. Krasner's office approves that. Is that correct?
That's correct under the rule.
And that would apply for all violent crimes?
That all misdemeanors, all felonies.
All misdemeanors as well. So Mr. Krasner's office is truly the gatekeeper to the criminal justice system here in Philadelphia.
That under the rule.
Yesterday we heard some moving testimony. None of us are built to bury our children, and we heard from mothers who have buried their children. In all of those cases, in all of those investigations, similarly, Mr. Krasner's office is the gatekeeper for those mothers to seek justice against the murderers of their children. Fair enough?
Correct, yes.
I yield back to the chair.
Thank you. Representative Ecker, you're recognized for questions.
Thank you, Mr. Chairman. I just want to highlight one thing that I think is a stark, just something that jumps out at me with all this data. And I, again, thank you for the thorough report. But again, turning back to page 4 and looking at that first bullet point up there on your report or on your testimony. And before I get to that point, I think in your testimony, a large number of the filings, I think almost 1/3 of the VUFA filings, are occurring in the city of the first class, Philadelphia.
Correct. Yes.
However, looking at that next bullet point that Attorney Rush alluded to, is that over the period of this, so from over the period of this report, there in Philadelphia, there has been an increase in dismissals, withdrawals, or non-pros from 7 to 21%. So a 3 times increase of cases being dismissed, withdrawn, or null pros, which is really during that same period of time.
That's correct.
And just so we're clear, that also would be the period of time primarily when District Attorney Krasner was in office.
I suppose.
Thanks.
Very good. Thank you again for being here today. I appreciate it. I would like to just follow up, and I realize some of these questions we've covered maybe a little bit earlier, but I do want to just wrap up with a couple questions. So we've talked a lot today. There's a lot of government speak, right? There's a lot of, terms that we use that we kind of assume and hope other people know what they mean. We've talked a lot today about VUFA, right? Could you just very briefly, for someone who might be watching on PCN at home, what is VUFA? What is that?
Yeah, it stands for Violation of the Uniform Firearms Act, VUFA. And in Pennsylvania, most of the offenses related to firearms are found in a subchapter, Chapter 61A of the Crimes Code of Title 18. So any of the offenses in that subchapter are considered violations of the Uniform Firearms Act.
And could you give the committee some examples of what those might be?
Sure. And in my testimony, I provided the list of the offenses, but I think I did, or in my slide. But I think the most common one we see is 6105, where a felon or someone who has been convicted is not permitted to carry a firearm, but is found with a firearm. But there's all kinds of offenses regarding licensing and the appropriate licensing, or misrepresenting your age or your criminal background in order to get a license to carry a firearm. So those are some of the common ones. And as I said, there's one specific to Philadelphia about carrying a firearm in the city of Philadelphia.
So if someone was carrying a concealed firearm in the city of Philadelphia without a permit, would that be a violation, for example, of
It would
VUFA?
be. It would be.
Okay. So you mentioned earlier that if someone violates VUFA, if someone violates the state law as it relates to firearms, that's handled a little bit differently as we look across the state. For example, if an individual was charged with illegally carrying a firearm in the city of Pittsburgh and charged with a violation under state law, who would file those charges?
One of the municipal police departments would file it without a review by the district attorney's office.
So the police department, and you said there's 109 police departments in
109
Allegheny
out of
County.
130 municipalities.
Yeah, that's got to be a handful for
It
sure.
is.
But
Yeah.
it's the municipal police department that's responsible for filing charges.
That's
Am I correct?
That's correct.
Okay. Who would file the charges here in the city of the first class in Philadelphia?
I'm not sure who does the actual filing, but the filing would have to be approved by the district attorney's office. So whether the DA's office files or police file after review or approval, under your local rules, there would be a provision about how that operates.
Your testimony noted that a higher proportion of VUFA, again, a higher proportion of gun crime, state violations of the state law as it relates to firearms, a higher proportion of VUFA dockets were withdrawn or dismissed in lower courts in Philadelphia as opposed to statewide. That's correct.
That's correct.
It looks to me that the rate of dismissal or withdrawal was about 50% higher in Philadelphia than the statewide average.
In some, yeah, for some categories, yeah.
And as you pointed out, the statewide average includes the city of Philadelphia. It's not the city of Philadelphia versus the other 66 counties in the state. That's correct.
That's correct.
So the city of Philadelphia greatly weights the statewide average that we're comparing to.
That is correct.
And it's still 50% higher in the city of Philadelphia as compared to the statewide average. Is that correct?
That's correct.
Is it safe to assume that the sheer number, the volume of these VUFA cases is significantly higher in the city of Philadelphia than as opposed to, say, Cumberland or Lehigh County?
It is, and partly that is the population, partly that is the density. And as I said before, we found in some other populated and dense counties, you find high levels as well, but Philadelphia is clearly in a class by itself.
Now, the data in your study here, which again is incredibly robust, you noted at the very beginning that the data is from the time period of 2015 to 2020.
That's
so
correct.
It's not up to the moment here, but it looks over that 5-year period. Is that correct?
That's correct.
And you note that the number of VUFA cases, so violations of the state law as it relates to guns, the number of VUFA cases withdrawn or dismissed in the city of Philadelphia has tripled in that time period between 2015 and 2020. Is that correct?
That is correct, yeah.
What could cause that type of dramatic increase?
I don't know. And that's one of the things that in our study, we recommended this need for, a very county-specific analysis, because there is something happening, and it may be exclusive to Philly, it could be other counties, but there is a disconnect where you're seeing either the need or the interest in that change from what was in place. And so it's not, maybe you arrive at some balancing point in terms of dismissals or withdrawals, other things like that, and it's the nature of the process. But what is sort of remarkable is when it changes substantially year over year, and the trend is in a given direction. So the question is like, why is that happening, and is there a basis that supports doing that or not doing that?
Very well. Are there any other questions from the committee? Very good. Mr. Bergstrom, again, thank you for being here today.
Chairman.
With that, the committee is adjourned.